a lot of cases end up getting dismissed. So they come up to the first court appearance after having signed a contract, agreeing to pay $10,000 or $50,000 over the course of monthly payments for 3 years or 4 years, and then the case is dismissed. The prosecutor decided not to file it, but the person wanted to get out of jail, right? Or you see people who have their cases either dismissed or thrown out later down the proceedings after they've served 5 months or 6 months or even a year in jail. And again, it's because we have this system of detaining people based on money. Now, is there a better way? Yes, there is. There are systems that don't rely on money, that rely on common sense criteria like, oh, does this person have a history of not showing up to court? Oh, does this person have strong ties in the community? And that's what we're advocating towards, moving towards that. And one of my heroes is here. Phil is going to talk about the work that he's done for our office. And one thing I want to emphasize is, I don't know how many of you are lawyers, and you may think, well, geez, I'm not a lawyer. How can I work on these types of issues? There's a lot you can add, because lawyers, for as much education and experience that we have, we miss things. And one of the big things I think we missed is filing these suits 10, 20 years ago. And Phil's started a nonprofit dedicated to overturning the bail system. And you filed suits, is it like 13 or 14? 11. Different cities across the nation, and has been successful. And he's going to tell you about what happened in San Francisco and what's happening also in Sacramento. But beyond suing, based on the Eighth Amendment, there is legislative reform that's happening. There's a assemblyman named Rob Bonta, who is working with the ACLU and other organizations to introduce a bill that would essentially replace the money bail system. He's going to face tremendous resistance because of the bail industry and the amount of money that they have. But to have that kind of momentum going into the legislative season, where he's already working with ACLU and a lot of other organizations like Phil's group that have been on this issue for some time, both nationally as well as locally. And then beyond that, on the ground level, what we've done in San Francisco is that we started a bail unit. We now have 4 attorneys who are dedicated to doing bail hearings in every case. Now, under the law, Penal Code Section 1275, we have the right to have a full-blown bail hearing, meaning that we can call witnesses, we can produce evidence in favor of a bail release. And many attorneys don't take advantage of this. Why? Because they're focused on fighting the case, or they're focused on other aspects, when the most important decision to the client is whether or not the client's going to be out. And that's going to drive the outcome in cases as well. And so what we've been doing is filing bail motions in every case and having hearings in every case. And it's driving the judges nuts. Because now, in addition to all the other matters they have on their calendars, they have 4 or 5 bail hearings. We filed some motions that were 100 pages long, and we're litigating these issues, and we're preparing even writs to the Court of Appeal. In every case now, we're raising racial justice issues in litigation. We're talking about disproportionate confinement of people of color, which is in San Francisco. Like 56% of our clients are black. Our African American population is now less than 5%. And we just had a Department of Justice report showing, and what we've known for years is that the police department is racist, whether you call it implied bias or explicit bias. Whether you look at the racist Texas or the indictments that resulted from our office's call for an investigation of officers who are violating civil rights, this kind of thing is happening everywhere. Right? Our numbers are actually worse than Ferguson if you look at the percentages of people of color and how they're treated. And so, armed with this kind of information, we're now actively litigating these issues and these issues of bail, questioning the bail system. And it's something that is going to be infectious. It is going to flow not only across the state, but across this country. And so David is really onto something in the Court Watch team, and the future attorneys and citizens who are part of this movement. We started a mini Court Watch program in San Francisco until Dave was able to bring his program out there, and there's a tremendous interest in it. We had 150 people come to our last Court Watch, and ours is on a much smaller scale. We only have it once every other month, and people come in for the day and go to an orientation and then go to court and watch the court, and they make movies or blog about it or write about it or talk about it. And there's tremendous interest in bail reform, in wanting to change these things, because people understand that it is a question of basic fairness, and we all have to look at it in terms of what would happen if I was in that situation, right? We know that there are people who are jailed for fines and fees, for not being able to pay tickets, for not being able to pay fines for misdemeanor offenses, right? There's a huge movement now to overturn that. And so it's actually a very, very exciting time to be a part of the criminal justice reform movement. And Court Watch has had the vision for many, many years. A lot of the things that they've been writing about are now coming into fruition. And believe me, I've been a public defender for 30 years, and I couldn't pay somebody to listen to some of the things that we talk about now. And I'm out, talking about these issues 4 or 5 times a week, and fighting, these issues in the court. And I've been going around the country, as I said, talking about racial justice litigation. But we have those same issues in San Francisco. I'm trying a case right now of a 22-year-old African-American young man who was falsely accused of robbery while he was on a BART train. And of course, he stepped out of the train, and the officers came at him with guns, and he took him down. And of course, he gets charged with 6 counts of battery on a police officer. It was one of the first body camera cases, so I decided to take it myself and try it, even though it's a misdemeanor case. And so I got sent to a judge to try the case. The first thing the judge says to me is, I don't want to hear anything about Black Lives Matters or Oscar Grant. And I had filed a motion to talk about racial justice issues during voir dire, right, during the time we get to question jurors. And so she did a couple other things, like gutted my defense, wouldn't allow, I had 2 witnesses on the BART train, a UCSF doctor and a retired chemist, who said my client did nothing wrong when he was on that train, and that the person who falsely complained that my client tried to rob him was lying. Well, she allowed the testimony of the complainant, saying that my client tried to rob him, and excluded the testimony of the 2 witnesses who didn't even know my client. And so when all of that happened, I challenged her for cause. And so now we're in the midst of a cause hearing. And it's crazy what's happened since that time. They appointed a judge to hear the challenge, and the judge denied the motion. Well, it turns out that they illegally appointed that judge, because they appointed a judge from their own court, which the law says you can't. So I wrote a letter to the Chief Justice, who was supposed to do the assigning, and so they ended up having to vacate that judge's decision. And so at that point, I incorporated that into the challenge, saying that the court and the judge conspired to have one of their own judges decide the challenge, and therefore should be excluded. I also brought in 7 other declarations of judges, of lawyers, who have had experiences with this particular judge, including one lawyer who had experience, and this tells you the important of Court Watch. What that lawyer said happened was that after his client was acquitted in a trial presided over by the same judge, the judge brought the jury in, and kept the lawyers out, what they're not supposed to do. It's an ex parte hearing with the jurors, and questioned them as to why they had acquitted the defendant. Well, the judge was ordered to respond to that, so she filed a counter declaration denying it, saying that the lawyer was lying. And so now I've subpoenaed the DA, who is also at the hearing. He's not happy about having to testify in that case. But I mean, these are the kinds of things that you're confronted with, and often it's hard because if you take on these kind of challenges, there are consequences.